Okay, it's 2 o'clock. Welcome everyone. Welcome everyone. It's 2 o'clock. I'm Stephanie Fisher with the Education Department at MBA. It's great to see you today. Thanks for joining us for how to minimize C-suite individual liability for employment-related claims. Our speaker today will help us identify the most common employment laws, describe who can be held liable under these various laws, and recommend preventative measures to minimize exposure for you. So we certainly look forward to welcoming James. Before I introduce him, just some quick housekeeping. We are recording. You just heard that notification. So I will send you that link. Be sure to share it with your team. We also welcome your questions. We're a small group today, so we certainly welcome them verbally. There'll be time for that, and then also monitor the chat, so you can type those in as well. So I will email you out James's slides too, along with a recording, so keep an eye out for that. I'd like to welcome our speaker today, James Reed. He is a partner with Dinsmore, a law firm based in Detroit, Michigan. He is also an associate member of Michigan Bankers Association and an important part of our membership. Whether it's representing clients or playing a game of chess with family, James goes all in strategizing and preparing for possible challenges facing his clients today, in months, even years in the future. He counsels business owners, entrepreneurs, C-suite execs, in-house counsel, and HR directors to make strategic business decisions from hiring to firing, while keeping you all under compliance with the ever-changing overlapping laws. James is a national speaker at conferences and events, including the American Payroll Association, our own SHRM, and HR Day, among others. Welcome, James. We look forward to hosting you.
Excited to be here, and I truly love this opportunity to make a very interactive group. So my plan for the next 58 minutes is to interact, ask questions along the way. I'm essentially going to share my top 10 stories that I've encountered since I started working at a law firm in 2004. And I also volunteer as the Society of Human Resource Management president for the state of Michigan and oversee all 19 chapters. So I'm aware of a lot of the hot employment issues even before they make it to litigation or liability. And I think the best way for all of you to get the attention of your managers and executives is to explain that many employment laws relate to C-suite individual liability. What I mean by that is not even just C-suite. It's any decision maker. For about 10 laws I'll be going over, is often sued individually in addition to the bank. About 20% of lawsuits now are including an individual on top of the company for violating the law, whether it's discrimination or violation of another law. So in order to minimize that exposure, I'm going to go over the top takeaways of how to do things properly, and maybe even at times have someone else make the decision, or have it be more like a team approach, so someone is not accused of having some type of illegal motive or violating any law. Without further ado, I'm James Reed, and the elephant in the room is, are there any more Jameses alive? And yes, my dad, the third, and my son, James, the fifth, are happy and well. Pressure is off. So for the agenda today, I'm going to identify all the common employment laws that we all need to be aware of, not just us, but also we need to train anyone in management. We need to describe who could be liable. And then I'm going to recommend preventative measures you can do now. So essentially all of you are more valuable because you're going to audit your own processes and implement change to minimize your exposure going forward. So the good news is there's recent case law that says you can't be sued for a Title VII violation under federal law. So what that is in a nutshell is that's the Civil Rights Act of 1964 that protects race, color, religion, sex, and national origin. So although you can't be sued individually for those, the state of Michigan and many states have their own anti-discrimination laws where you can be sued individually. So be aware, most handbooks don't even include the Michigan protected classes. That's a mistake. That means that company probably bought an off-the-shelf handbook that was federal law compliant and didn't take the time to make it also state law compliant. So a quick refresher, the state of Michigan, what would be fun interaction if someone wants to type in the chat box, any protected classes they're aware of under state of Michigan laws. And I would love to share a story with those as you type them in. But to give you an example, I think we all know race, black, white, other races, color, the color of your skin. Religion is not only, Christian or Jewish or Muslim. It can be any sincerely held religious belief. So I have seen situations where someone, claims to have a religion I've never heard of and needs to miss work. Those are situations you have to take seriously. Even someone that, I'm not using the appropriate term, but believes in the religion of being a witch can be a valid religion that you have to see if you can accommodate when identified. And then with sex, that was expanded last summer, where sex also protects sexual orientation and gender identity. So I've seen many of your handbooks where you say, a woman bank teller can wear a blouse, a man has to wear a suit and tie. It is now illegal to stereotype how there should be gender, neutral dress code policies where any sex can wear all clothing that is approved, and also national origin. Under the state of Michigan, great answer, identifying weight as a protected class. And Michigan protects height, weight, marital status, family status, misdemeanor arrest record. So on all of these topics, we have to be careful when our management level are making any weight jokes, whether to gaining your COVID-19 or losing your COVID-19. Any type of jokes like that, you don't necessarily need to terminate somebody when they make a joke based on a protected class, but at a minimum, you should warn them that, it's against company policy to joke about any protected class. This is the main theme I'm seeing in 2021. So even if you're not intentionally, discriminating against someone based on weight or some other protected class, you could unconsciously be doing so without realizing it if you have a consistent pattern and practice of favoring or disfavoring a certain protected class. So we're seeing more and more lawsuits where when there's a reduction in force, where right now it's not really the problem, it's the opposite, finding someone with a pulse. But if you are laying people off or making changes, you want to make sure that you're not singling out one particular race, sex, religion, etc. And then with the marital status and family status, that is becoming a more common trend, because right now a lot of people that are logging on remotely or during small talk, you find out if they're married or they're single, or you have to decide who comes back to the office, maybe who can stay home and work remotely. And you can't just say, hey, if you have kids, you can work remotely. I had one client that said women can work remotely because they have students to attend to, and men need to be in the office. That would be blatantly illegal. So the most common employment law claims are Fair Labor Standards Act claims. So that is a federal law where you have to pay overtime if somebody works more than 40 hours in a week. The state of California has their own state law where if you work more than 8 hours in a day, you get overtime. That's not the case in Michigan. However, the Fair Labor Standards Act applies to all overtime and minimum wage. So if you are giving people a bonus and you're not factoring in that guaranteed or formulaic bonus into their hourly rate, you need to. That is the Department of Labor's hot button where they are analyzing and auditing companies to make sure that you're not just paying someone $10 an hour, but really they're averaging $12 an hour because of the bonuses and additional payments they're getting. The only way to exclude that bonus from an overtime calculation is if the bonus was truly discretionary and optional and not based on any formula, more based on, goodwill or some other, variable. And a lot of banks are misclassifying their employees. Anybody in a sales capacity or anybody, mortgage loan officer or other people, you're just assuming you pay them a salary and they're not entitled to overtime. That's only one part of the test. You also have to make sure those employees have job duties that meet one of the 5 standard exemptions. So are they managing 2 or more full-time workers? Are they able to make significant decisions on their own, such as hiring and firing? Are they truly outside sales and never come to the office and, have duties where they're trying to develop new business and have discretion to negotiate? Those are job descriptions need to be revisited, especially in for ERISA, Employee Retirement Income Security Act. There is individual liability exposure, and under the Fair Labor Standards Act exposure, and there's also individual liability. Under the Family Medical Leave Act, which if you have 50 or more employees within a 75-mile radius, there's individual liability for violating that law. Under COBRA, the Consolidated Omnibus Budget Reconciliation Act, there's individual liability for violating that law. So if you lay somebody off and don't give them the paperwork to continue their health insurance, you could be exposed to individual liability. Under OSHA, if you are not providing a safe work environment, you could be held individually liable as well. And under the Immigration Reform and Control Act, you could be liable individually if you, aren't following the procedures on the I-9 paperwork or not getting, ID verification of who somebody is. And then there are many, many state law discrimination claims where you can be individually liable, such as, the common ones are, state law discrimination claims, also libel, slander, defamation. So even though the state of Michigan has an immunity law where if you tell the truth or you tell another employer, how bad an employee was based on the truth of your opinion, you are protected. Many banks don't allow HR or executives to say anything other than the time period worked because they don't want to have to defend what they were saying was actually true and make sure they don't want to be at risk for libel, slander, or a defamation claim. We're also seeing the C-suite liable for other actions, including, assault and battery, which could be, a verbal attack or a touching, false imprisonment, essentially restricting an employee from, able to leave their space, tortious interference with an individual's contractual rights. I'm seeing a lot of this in the banking world where banks are encouraging, or executives encouraging someone to violate their non-compete, saying, oh, that other bank isn't going to enforce it, or telling them to ignore their previous employer's contractual obligations, invasion of privacy, intentional infliction of emotional distress, conspiracy to violate someone's legal rights. So I could go on and on and on, but the theme here is that on all of these common employment issues, you could actually be individually liable. So, and also with the lack of diversity at many organizations, including banks, we need to, more than ever, not have the most senior old male make all of the decisions on all of these issues. We need to have a diverse, and don't make it solely the HR professional making these decisions either. I highly recommend a diverse board or a committee where the committee approves a decision to terminate somebody or take some other adverse action, so that there is no allegation of unconscious bias that was factored in. Or maybe you're learning things that the other committee or board members didn't know, and that would be a strong defense to where those facts were not accounted for in making a business decision. So now that I maybe scared everybody, it's not Halloween yet, although it feels like it's fast approaching. What should we be doing to minimize the bank's exposure? So with regard to the Fair Labor Standards Act, I'm highly concerned about wage and hour claims for non-exempt employees, because they might be working at night, they might be answering phone calls or responding to email, or even reviewing email on other devices remotely. So we want to make sure all time is properly reported, and we want to make sure that we are aware of the hours our employees are working and how we're paying employees for the hours worked. So tip one, let's create a committee to make all payment decisions. If we're gonna, give bonuses or change compensation structures, have multiple avenues that allow the employees to report concerns. Because I've had many claims where a bank teller says, I couldn't report my overtime because my boss said I wasn't allowed to work overtime. Well, that is not a defense for a bank or a company. If somebody works overtime, even though you have a policy in your handbook likely that says you are to pay the employee all time actually worked, even without approval, you could just write them up or discipline them for violating your policy. And then you want to reevaluate your compensation structures and make sure bonuses are included in overtime payments for those non-exempt employees. And, I'm happy to be a scapegoat. You may want to have outside counsel approve your job descriptions or approve your termination decisions, so that, you relied on a legal expert. With the Department of Labor, for Fair Labor Standards Act violations, they define a willful violation as not having outside counsel approve your pay structure. So even though you tried to follow the law and got it wrong, that would still be deemed a willful violation, even though you didn't intentionally try to violate any law. Under the Family Medical and Leave Act, individuals could be liable if they're, denying someone leave, saying, I don't think you're pregnant, or I think you're faking it. You could be individually liable. So, in this regard, always rely on a doctor note, and let's not play doctor and try to second guess a doctor's note. We have to rely on the doctor's notes. We are not doctors. There are times where you may want to get more information. So what I highly recommend is preparing like a fitness for duty certificate, where you identify all of the essential functions of the job and ask the doctor, give it to the employee, but have the employee complete whether or not they're able to do all of the essential functions of the job with or without a reasonable be able to in the future. There is no duty to accommodate that employee by removing an essential job function. That's not a reasonable accommodation. The only way to accommodate is to see if there's a way to get the employee to actually perform the essential functions, or if you're openly advertising a job that they're fully qualified for, maybe accommodate them by letting them go to that other job and pay them whatever that other job would normally pay. Now, please, for those that are logging on recently, please type in the chat any questions or just turn on your camera, unmute yourself, and let's go through any hypothetical that comes to mind. Another way to minimize risk under the Family Medical Leave Act is to use a third-party administrator to process your leave paperwork to minimize your liability. And when somebody, when you're denying someone's leave, make sure you have evidence justifying your reasons to do so. And I do see employees that get terminated while they are on leave, and that is okay if there are legal reasons to do so. So if you were going to terminate the employee without factoring in the need for FMLA leave anyway, let's say you discover in their drawer they were hiding, a bunch of work, not paying bills, having sloppy work product, or stealing money, you would be able to fire even though they were on leave. You want to make sure you have paperwork, justifying any approval or denial. Make sure you're working closely with HR. And what's so hard about all of your jobs is that somehow the employees always know how every other employee was treated, even if they go back years. And while it is legal to treat people differently, it looks bad if you treat people differently. If you treat people differently, the Equal Employment Opportunity Commission will take a much closer look and essentially believe maybe you're treating someone differently for an illegal reason instead of a legal reason. So if you are treating people differently, maybe identify your legal reason for doing so, such as you're trying to attract new talent, or someone is just, an exemplary employee and, they earned the right to have that additional privilege. But when in doubt, if you treat everyone the same, that'll minimize any claim that you discriminated against somebody. So it's a two-part test. One is, are you handling the situation in front of you fairly and appropriately? Part two is, do you have the intel on your bank or organization where you can see how everyone else was hired or fired or disciplined for a similar violation, because you want to try to apply those facts similarly. However, there are times to improve and change. So you could say maybe the reason you're treating employees differently as of today is because you attended this webinar and now are more sophisticated and want to follow takeaways and tips that you gathered from this webinar. And I highly recommend that all of you get training for your entire organization, even if it's a 30-minute, voiceover PowerPoint or video. I don't believe anybody read front to back the entire handbook except for maybe HR or your lawyer. So I would want you to do a summary, maybe through a table of contents, kind of explaining what's expected of the employee to make sure that they are aware of the rules and procedures to follow. And maybe you want a separate management training for all managers, because you don't want to overeducate the lower level employees on how to spot claims to bring against the company. So ERISA and COBRA, I don't know if any of you deal with, health insurance plans or retirement plans or COBRA, but anybody who exercises discretion is deemed a fiduciary and can be held individually liable. So in this regard, you'd want to rely on a third-party administrator. Or I have seen employees, if you are taking on these risks and these liabilities, I've seen times where it makes sense in your employment agreement to have an indemnification agreement to the extent you're helping out as a third-party administrator or processing these legal issues. You will not be held individually liable for any claims, and the bank or company will, indemnify and defend you from any claims, so you're not individually on the hook. Plaintiff attorneys are strategically including as many individuals as possible in complaints, because if any of you see your name in a complaint, you're going to encourage the bank to settle the case ASAP, because you don't want your name out in the public or on the news, and you might be stressed out that financially you are exposed. And you want to make sure that with COBRA, you're also relying on a third-party administrator, get your indemnification agreement, at least have training on how to follow your obligations under ERISA or COBRA, understand, all the triggering events that give rise to COBRA. So during COVID, whenever there's a change, I think that's times where you're spotting issues and need more guidance. So during COBRA, when employees were furloughed for more than 90 days, the health insurance plan required a COBRA notice to go out to even those employees that were still employed. So you can be on COBRA and still be an employee at the same time. So to give you, another example is, let's say someone is on family medical leave and they aren't coming back within their 12 weeks. Well, maybe that 12-week protection expired, but you may still have to give them a COBRA notice if you're accommodating, let's say a disability where they need another week or two before they're able to come back to work. You also want to make sure you're acting timely in all of your notices and contributions. You want to make sure you're, sending out your plan documents promptly. You don't want to summarize any of your health insurance or plan documents in a handbook. Instead, you want to refer to those plan documents. And you want to make sure that your processes are audited, and you need to have an annual fiduciary training plan for any of your administrators. For OSHA, you may have seen a major uptick in OSHA claims. Typically a bank, you think you're pretty safe, maybe you're going to get a paper cut or, something minor. But with COVID, I've had literally dozens and dozens of client calls where my OSHA are coming to the and some clients have told OSHA, oh, masks are optional here, even when they were mandated at the time. Or they'll claim, COVID is a hoax, or they'll say other things to these investigators. First of all, you want to make it clear if the government is coming or an agency is coming to your bank or office location, who has authority to speak on behalf of the company? Who should that visitor be directed toward to make sure it's handled appropriately? And the number one most common employment claim is reports their boss or somebody for not wearing a mask or not washing their hands or grabbing the coffee pot without wiping it down or grabbing the refrigerator. Or, I've seen the most petty issues be raised over the past 17 months. We want to make sure that there's no perception that we're retaliating against any employee that is identifying, safety standard requests. So one, I would revisit your COVID policies. I would make sure that you're updating your program as new guidance comes out. Make sure you're training your employees. It's actually required under my OSHA to have a COVID plan and training. You also want to make sure that you are logging, any type of accident investigations, and you have procedures of how to, immediately investigate any safety concerns. You have programs to prohibit retaliation, but even when you are prohibiting retaliation, you don't want to guarantee whatever the employees say will be confidential. At times, we have to disclose witnesses as part of our investigation process. And before you take an adverse action or terminate or discipline, and when I say adverse action, I usually mean firing, changing their pay, or demoting them. That's where you want to make sure you have a legitimate reason to do so. And the biggest problem that I'm seeing in HR is too caring and too trustworthy, and no good deed, good act goes unpunished. So when you're asking, other people why that person should be disciplined or terminated, you're believing that they say they're a bad person, or they're ineffective, or they just say some conclusion. That is not good enough in this day and age. Whenever you are in front of a judge or a jury or any investigating body, you want to have evidence. So you want to have literally an exhibit of the who, what, where, when, why, witnesses, wants, how, facts, pictures. You need to have actual facts, not just conclusions, before taking an adverse action against your employees. And just to kind of go over the common violations of OSHA are anything, COVID related, not providing sufficient training, and this can all relate to personal liability. So I highly recommend that you allow employees to report anonymously, sometimes even to outside counsel or a third party, so they don't claim a freight, especially at a smaller bank where it may be, more everyone is part of the same family, and you may feel there are alliances or favorites, or it's so small that you're afraid of retaliation. Sometimes great to have an outside party to report issues to. Right now with the Immigration Reform and Control Act, a lot of I-9 questions are coming up, especially with COVID. Are you approving, people remotely with their paperwork? And, are you knowingly hiring unauthorized workers? Are you using E-Verify? And are employees properly trained on how to spot and identify these issues? And then there is what's called common law. And common law basically means individuals are liable for their own actions taken against another person's property or against another person directly. So what I mean by this is if you're, have employees that are doing things outside of the scope of their employment, they're taking out their mentees for drinks at a bar, or they are, driving routes outside of their working routes. You want to be extra careful that they are not unnecessarily exposing themselves or, the bank to any liabilities. So make it clear to employees. I would update your job description and tell them they're not directed to perform anything outside of the scope of that job description. And then again, use a committee approach in making your decisions, not just the president anymore, and make sure that you're documenting reasons for your actions. Even though you don't have to by law give every documentation you're putting in an employee's file to that employee. You can secretly put paperwork in an employee file, or you can have a investigation file and decide over time if you want to put that investigation file or notes into that employee's personnel file. And I've also redacted names and information from an employee file to protect the innocent. So under Michigan law, we have what's called the Bullard-Plawecki. Under that act, employees are entitled to their personnel file in Michigan that has the good, the bad, and the ugly in their file. But where banks sometimes make a mistake is they basically give that file out upon request, where in reality, in this day and age, we probably have text messages, or to the extent you don't have policies prohibiting that. But even if you do, I know a lot of critiques or information from text messages, emails, or other communications that did not make it into the personnel file. So what I usually do is give an employee a cooling off period and make them wait about 28 days to give us time to make sure that we're not producing documents that we shouldn't, we're redacting information that we should, and we're gathering, paperwork and information in other locations, so we're able to have the full and complete file. And the reason why we want to have the full and complete file is because the way the bulletproof wiki law applies, it's like poker. If you, your hand is the hand you build in that file. And if you are trying to defend a lawsuit and want to produce other written evidence or exhibits, you're prohibited from doing so if it was not in the file at the time of disclosure. So this is the time to set your poker hand and make sure that you have a winning hand. However, I have seen banks that go overboard by having a file that's this thick for one particular employee, and none of the other employees have anything in their file whatsoever. So it looks like we were over covering ourselves, possibly to retaliate or cover up some other illegal reason. And when I say, discrimination or harassment, I mean it under the legal term. So to be harassment or discrimination, it means that you have to have an adverse action on an employee for an illegal reason. So if you are being hard on an employee for legal reasons, they're missing deadlines, they're late, they're not improving, that is not harassment. Would interpret, anyone that has a rude tone or is condescending as a bully, harasser, or discriminator. And you are allowed to discriminate. You can favor the higher performers over the lower performers, or you can discriminate for any reason that isn't illegal. Employers don't have to get it right and always, reward the best employee the most. They can reward whoever they see fit, as long as it isn't for illegal reasons. So, what are the best ways to minimize risk on all of the issues that I raised today? So, one, in your employment application, I'm seeing an uptick in claims of employees that are not hired, saying they believe they were not hired because they disclosed some protected class in the interview. Or maybe they'll even talk about their protected classes and initiate those conversations during the interview. So if those employees aren't hired, there's often not even a personnel file on those job applicants. So you don't want those employees to sue you and have a jury trial. And if someone were to sue you under state law, they can skip the Michigan Department of Civil Rights or the Equal Employment Opportunity Commission and go straight to court. But if it's a federal claim, they have to first go through the administrative agency. But then, whether or not there's any merit to their claim or not, that employee will have a right to sue letter, and they are a jury trial unless you have an alternate dispute resolution procedure in your job application. So what you'd want to say in your job application is, in consideration of your application for employment, you agree to waive your rights to a jury trial. That is enforceable under most circumstances. You may also want to say that employee agrees to bring all claims within 6 months instead of 6 years for like a breach of contract claim. Reducing the statute of limitations is enforceable under some scenarios. It's actually not enforceable under discrimination law laws federally and not enforceable under the Fair Labor Standards Act, but it is enforceable in other regards. You may also want to, require mediation or private arbitration so that you don't have, the Channel 7 News or 247 verifying whether or not you are, on social media acting appropriately. You don't want to have a social media trial. You want to maybe have a private lawyer decide how to resolve your dispute. And I'm getting some great questions. Is it going to be hard to hire somebody if you have this spooky legalese on a job application? And I've done well over 1,000 of these. I've never had one issue. I honestly think that when an employee fills out a job application, they are not even reading anything other than the blank lines of information being requested. And under the law, an applicant or an individual is deemed to have fully read and understood any contract placed in front of them, regardless if they read it. So I've not had that be an issue. And at the time somebody wants a job, they will typically sign anything in order to have the opportunity to get a job. I often see employees, ask you legal questions during interviews, and they answer them anyway, because even if they have a claim or have maybe a reason not to participate, they don't want the person not to like them and potentially not hire them for legal or illegal reasons. So you want to cooperate. So I have never seen that be an issue, but if it was raised, I don't have a problem saying, what's the big deal of having you agree to bring your claim within 6 months? You should know whether or not you have a claim prior to then. And the process of arbitration can actually be cheaper for both sides. It's actually free. The arbitrator under employment laws are paid by the employer. And it's a faster process to get justice for the parties involved. So I don't have any problem on that. But let's say you do, you could put that in an employment agreement, or you could put that in an offer letter, or you could put it in a handbook acknowledgement where someone signs, I received the handbook, I agree to follow it, and I agree to resolve these disputes the following way. In consideration for employment, that is sufficient, even though you're not getting necessarily money for signing the contract. The opportunity for a job is sufficient consideration to make that an enforceable agreement. You also likely want to waive class actions, because on a lot of these issues that I covered today, if somebody has a misclassification, let's say they're a mortgage loan officer that's paid a salary and not getting paid overtime. And by the way, there could be an MLO that is exempt if they're managing 2 or more employees, et cetera. But let's just, following that example, if there's a misclassification, that probably applies to all mortgage loan officers. So to minimize class actions and getting teamed up against by your employees, you may want to add a provision that waives class actions. So there are contractual strategies to minimize your risk and exposure. And by requiring employees to report issues and give you a chance to investigate and resolve them on the front end, that can also save the day. Second, you want to make sure that you obtain employment practices liability insurance. I would guess that probably 80% of those attending today's webinar have it, and you may or may not know that you do. So I would work with your insurance agent to ask if you have it, but if you do, that could cover all the discrimination claims, maybe all of these claims. With wage and hour, they aren't going to pay your overtime out of insurance, but they may often pay your legal bill in defending any misclassification or wage and hour claim. Third, when you are terminating high-risk employees or any employee, even of low risk, you may want to offer a severance agreement so that, and it doesn't have to be a windfall of money, maybe just agree not to challenge their unemployment benefits and pay them out their unused PTO, even though by law, you don't have to pay out unused PTO unless you have a contract stating otherwise, in exchange for having them release claims on the way out. Next, use a committee to minimize any illegal factors in the decision. And fourth, make sure you're documenting your legitimate reasons for making your business decision. Now, before I cover my final case example of the day, I want to make sure I'm answering all of your questions. So a couple of questions that came in. One, are gender specific dress codes truly illegal? That's a great question. So I would argue that by giving examples, it's not illegal unless you don't allow an employee, like let's say there's a male employee, the Harris Funeral Home case, you may want to read. That was a Michigan case where an employee that identified as a man came back from vacation identifying as a woman and wanted to wear a dress as a funeral home director. And the employer fired that employee essentially for wanting to wear a dress. And that went to the Supreme Court of the United States and was deemed a unlawful reason to fire an employee. So I guess if you have the policy, what are the damages if there's no adverse action? So if a male, someone born as a male identifies as a female and wants to follow the, woman dress code, I highly doubt there'd be any issue unless you fire the employee for trying to follow that dress code. But yes, if you did apply it differently, there would be liability exposure. This Harris Funeral Home case came out last year. So someone is not, and that's why General Motors and a lot of other companies are now saying business professional and allowing the manager, because maybe someone that is working remotely or not customer interfacing doesn't have to dress the same way as someone that is. Next, someone has a job application that essentially says that the applicant agrees any action arising out of their employment, including all claims, must be brought within 180 days. That's good. However, there's recent case law that says that's not enforceable in all areas. And it looks like you even have a disclaimer identifying that. So yes, it looks like that is a sample. Banks should share their best practice samples. I'm also open to sharing language or doing a free audit of your language to see if there are any glaring loopholes. I haven't had a chance to read every word on that, but I do support sharing best practices. So one kind of case to get us thinking is I've seen situations where management or HR investigates a situation and upper management doesn't agree with how HR is investigating or handling the dispute. And so there are now protections based on this case where if any of you are in good faith investigating an issue and you get retaliated against for saying, hey, I think there's actually, some exposure here on our wage and hour matter, you cannot be fired or retaliated against for identifying landmines at the bank or organization, even though that's your job to find those. You're not really engaging in protected activity unrelated to your job. That's still considered protected activity that could protect your job. So without further ado, that summarizes what I wanted to cover today. And I could share stories forever, but we have 10 minutes left for Q&A. If anybody has any specific questions, or it's legal advice hour, if there's anything unrelated to this that you want to throw at me, happy to discuss it. Thank you.
Thanks, James. Any questions? It's free legal.
Free legal
Wow.
advice. And while
There you
we're
go.
waiting for questions, what I really have found powerful in my recent presentations is if you identify at least one takeaway, like if there's one nugget you learned, just by typing it in the chat box, that'll make us a little more aware that maybe we learned that too, and we can make sure we apply it back at our bank. So if there's anything new you learned, or if you already knew all of this and learned nothing new, type that in as well, so I'll know to get more sophisticated in my next presentation. It looks like someone is learning that the protected classes are much broader than they realize, especially with religion and even with sex, with the dress codes, etc. And the Supreme Court of the United States, I think, is ripe to get a religious issue kind of combating a sex issue. And we'll see how there are overlapping protected classes in the near future. And just to add a third thing, if there are any topics that you want to be covered in the future, please type those in the chat box as well, and we'll try to tailor our presentations further. Workers' comp appears to be a hot issue. That doesn't really apply to COVID in most circumstances. COVID is kind of deemed like, being sick outside of work, and rarely are you able to get relief through workers' comp. People are learning, about the Michigan specific protected classes, being careful with, workplace jokes. And that is a good reminder. So when someone, violates best practices, they don't necessarily have to do a formal meeting and write up and say, this is your final warning. You may want to do a softer touch where you do a policy reminder to the whole bank saying, just a reminder, we don't want to have any jokes based on any protected class, or, reminder on our dress code, people are getting a little more comfortable and loose, in this environment, please be reminded of our policies.
Okay, if anyone doesn't have any more questions, thank you for joining us. We appreciate it. Thank you, James. This was very insightful. And I will share your contact information when I send out the recording. So if any questions come to mind, you can certainly keep in touch with James there. And please, any topics that you need, let us know.
It was a pleasure seeing all of you, and everybody have a great back to school season.
Thank you.